Thank you.
Thank you.
Good afternoon, Honorable Chair and members. My comments have already been submitted. I'm here as the Mayor of the City of Montebello to express that the City of Montebello, unless there are provisions that are amended which are harmful to local governments, we will continue to oppose this bill. Some specific issues of concern is that this proposal continues to prevent reinstatement of all but a small percentage of loan agreements between a city and its redevelopment agency, and revokes a promise made by the legislature to cities that have complied with the dissolution mandates. This change could cost the City of Montebello over $4 million. This proposal significantly restricts the ability for communities to seek judicial review of Department of Finance determinations by exempting the Department of Finance from compliance with the Administrative Procedures Act and eliminating litigation funding for successor agencies. These changes would virtually immunize the Department of Finance from oversight. This proposal reduces funding to successor agencies that are working to wind down the affairs of their redevelopment agency by precluding funding for property maintenance expenses and other costs and retroactively invalidating loans made by a city to assist the dissolution process. The city strongly supports the property tax override provisions, which we support selective provisions of the proposal that would require revenues of voter-approved pension taxes to be allocated to the levying entity. This is a much-needed revision to the law required to fix unintended consequences of redevelopment dissolution. In Montebello, this amendment would provide over $3 million annually to fund pensions for police officers and firefighters. Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee. I promise to keep it as short as I possibly can. My name is Jillian Van Meiden, and I'm the Chief Assistant City Attorney for the City of Glendale. The principal issues we're interested in with respect to this bill are the LAIF rate issue and the interpretation of the loans. We are concerned about the amendments that would preclude oversight through the Administrative Procedures Act and limitations on the ability of agencies to fund litigation. But let me focus principally on our issue, and that's the LAIF rate issue. It is clear to the City of Glendale, as confirmed in the March 16th decision by Judge Shelley-Ann Chang in the Sacramento Superior Court, that Glendale's interpretation of that code provision, which is 34191.4, is that the LAIF rate is the rate in effect historically and as adjusted on a quarterly basis, and is governed by the state statutes governing LAIF. Interestingly, the difference between for Glendale between the LAIF rate application to our outstanding loans, which include reimbursement agreements, but I'll be getting to that issue of the definition of loans, is approximately $30 million in interest. If both the definition of the loans as well as the LAIF rate definition, the DOF's proposal is adopted by the legislature, that will result in an approximately $43 million loss to the City of Glendale. We have cut our budget by $50 million. Everything but core services, you'll hear it again and again this afternoon. What will get cut now are police and fire. And we know that other cities are benefiting, and we're happy for them, City of San Francisco for affordable housing, but Glendale will be losing a payment of $8 million to its affordable housing fund, and we also have affordable housing needs in our city. So what about the LAIF rate? We believe that we beg to differ with the position of the Department of Finance, but we believe that we will prevail on that issue on appeal and feel very strongly about it, that it is a very basic issue of statutory interpretation. Getting to the issue of the interpretation of the meaning of what is a loan and if it's just for cash value, as opposed to what the representative from the Department of Finance says, that it is 34179D, which are the definitions of enforceable obligations that govern. That's actually not what the statute says. It says, notwithstanding subdivision D of section 34171, Upon application of the successor agency and approval by the Oversight Board, loan agreements entered into between the redevelopment agency and the city and county that created the redevelopment agency shall be deemed enforceable obligations, provided that the Oversight Board makes a finding that the loans were for legitimate redevelopment purposes. What we know historically, and this is based on the Health and Safety Code authorizations for redevelopment agencies, is that cash loans were not the only basis of financing. Advances were permitted. Reimbursement and cooperation agreements, all variety of financing arrangements were allowed and encouraged under the Health and Safety Code. Furthermore, if I could refer you to the State Controller's report on redevelopment, it makes reference, this was the last year that the statements of indebtedness by all redevelopment agencies were reported and collected and reported by the State Controller. Makes references to what that outstanding figure was based on that self-reporting. It includes loans and advances. So this was recognized on a state level that this was the way that redevelopment was done. Redevelopment project area life ended, and then there were 10 additional years with which agencies were allowed to repay their indebtedness, could no longer undertake redevelopment activities, but 10 additional years. In order for redevelopment agencies to exist, they had to maintain debt. And so they were encouraged, and it's now easy for us to Monday morning quarterback what redevelopment agencies were legitimately permitted to do under the statutes, but that is precisely what they were permitted to do, was to incur indebtedness and wait until the end of the project area and in order to repay those loans. So you will hear that repeatedly as well.
But was there specificity on how much or ratio on how much the debt should be?
No, there was no specificity on how much
pay
the debt could be. It could be little or it could be a lot. But if you think about the way redevelopment agencies function, they could either commence repaying all their debt at once and not have cash flow in order to fund the redevelopment projects for purposes of blight elimination, such as capital improvement projects like the City of Glendale undertook. Or they could just repay the debt. So the purpose of redevelopment was basically to borrow money and early on seed money from its legislative body, from its city, its community organization, or from other sources it was authorized to borrow money or to seek advances. And often those were where property or services were provided through the city because that was the most efficient purpose or method with which to obtain those types of services for capital infrastructure improvements and core improvements within a city, within a blighted area. So that was the structure and the framework of redevelopment historically. And we sit here today and we can criticize the way that was done, but that's what agencies were permitted to do. They were allowed to delay the repayment on those loans, and you will hear that that's what they did. That's why you're hearing today that you have these loans that are outstanding over a period of time, and that would include the City of Glendale. You will also hear that many agencies charged exorbitant rates to the cities that charge exorbitant rates on the repayment of these loans. That was not true in the City of Glendale. We maintained our portfolio rate, or we tracked along with the LAIF rates. And we do know that the LAIF rates historically have fluctuated. Now they're quite low. They're below 1%. But there were times over the years where they exceeded 10% for short periods of time. But the average rate, and we calculated it based on what's published from 1977 to 2015, was actually 5.614%. That's the average rate over that time period. Anyway, I just wanted to provide a little bit of information to the committee because we're right in the thick of this. It's a lot of money for Glendale and its core services. Those are our two principal issues, as I said. It's the LAIF rate and its interpretation. We're encouraging the committee to consider voting in opposition to those pieces of the bill, holding them open until the courts of competent jurisdiction have had the opportunity to review both the LAIF rate issue and the loan interpretation issue, which is open and on appeal on behalf of the City of Watsonville. And I'm available to answer any questions should the committee have any questions for me.
Thank you. I think we will, because what I'd like to do is actually go back to Mr. Hill and ask, why don't we go, since we have 6 individuals standing, why don't we have all of them speak? But then what I would like is for you to have the opportunity to respond to some of these issues that are coming up. So let's continue.
Thank you, Mr. Chair. Members, I would echo the comments of Glendale. I represent the city of Glendale, Sacramento, and Murrieta. Murrieta has a $5.3 million issue at stake that they think would be jeopardized by this bill. We find this whole allow the trailer bill is moving the goalposts. We've won some court cases, and we think that this is an unfair way to go about it. We would recommend that things that are subject to courts be left in the courts and not changed by this body. We urge a no vote. Thank you.
Thank you.
Mr. Chair and members of the committee, my name is Brent Hawkins. I'm an attorney with Best & Krieger. I'm here today on behalf of the cities of Montana and La Habra, who urge the committee to oppose this bill because it further erodes what are already inadequate protections against arbitrary decision-making by the Department of Finance. It does this by first exempting the Department of Finance from rulemaking under the Administrative Procedures Act, and requiring litigation costs to be paid from the administrative cost allowance. Let me give you one recent example of how the Department of Finance has abused the authority it has under the dissolution law. In 1982, the Fontana Redevelopment Agency and a private developer entered into an agreement to finance the public infrastructure necessary to develop thousands of new homes in the city of Fontana. The infrastructure included not just backbone infrastructure like streets and water and sewer, but schools and fire stations. Under the agreement, the private developer fronted the entire cost of this public infrastructure and was to be reimbursed with interest over time by the redevelopment agency from tax increment generated in the project. To assure the developer and its investors and lenders that the redevelopment agency's reimbursement pledge was binding, the financing agreement and 3 amendments to it were validated by court judgment, the latest occurring in 1992. The court specifically found that the financing agreement was lawful, just, and reasonable. Just earlier this month, the Sacramento Superior Court issued a decision in which it specifically found that the financing agreement was a valid, enforceable obligation under the dissolution law. The developer completed the construction of the project, including the public infrastructure, in 1992 at a cost of nearly $200 million. The developer has been receiving annual reimbursements under the agreement and has so far received approximately $170 million in reimbursements. When the Fontana Redevelopment Agency was dissolved, the successor agency listed the obligation to reimburse the developer under the financing agreement on its semi-annual Recognized Obligation Payment Schedule, or ROPS, which was approved by the Oversight Board and by the Department of Finance on multiple occasions over the past 3.5 years. Just last week, Fontana received a final determination from DOF on its latest ROPS that despite its previous recognition of the financing agreement as an enforceable obligation, the 4 validation judgments holding the agreement to be a valid enforceable agreement, and the recent Superior Court decision holding the financing agreement to be an enforceable obligation, the Department of Finance would no longer recognize the agreement as an enforceable obligation and would not approve the allocation of property taxes needed to pay the obligation. The primary reason the department gives for this determination is its claim that Fontana has not provided it with adequate documentation. In fact, Fontana has provided the department with everything it has asked for, including multiple binders full of documents. DOF's explanation fails to account for the fact that it obviously had sufficient documentation to approve the agreement multiple times in the past 3.5 years. I raise this issue not because I expect the committee to solve it. There is a legal process for that. But because it illustrates how arbitrary DOF has been in administering the redevelopment dissolution process and how ill-deserving it is of even greater authority as proposed in this bill. With the Department of Finance, nothing is ever final, and its previous actions can never be relied upon as a predictor of what it will do in the future. Doing business in this kind of an environment is simply impossible. It creates such uncertainty that it is impossible to budget or to plan more than a few months at a time. Fontana urges the committee to reject DOF's budget trailer bill, not because the existing dissolution process is working so well, it isn't, but because this bill will only make it worse by giving the department greater authority when it has shown itself incapable of fairly exercising the authority it already has. Thank you.
Thank you. And Mr. Hill, I'm going to ask you to comment on that as well, especially given whether still there's a maintenance, if there's the belief that maintenance is still under the enforceable obligation. So, but if you don't mind, just wanted to make a note of that with you. Let's continue. And if I, at this point, can impose a 2 to 3 minute limit, please, so that we get through everyone, and then have at least some level of a dialogue afterwards.
Thank you, Mr. Chair. I'll see if I can keep this to 30 seconds. Jonathan Clay on behalf of the City of Coronado. We echo some of the same concerns. The City of Coronado is one of the cities that have been in the litigation over re-entered agreements. We have just concerns similar to the League of Cities regarding interest rate, also the lack of clarity of how this whole process is going to come together. We greatly appreciate that the re-entered agreement language that was in the original trailer bill has been removed. Thank you.
Thank you.
Good afternoon. Christine Carson, Deputy City Attorney for City of Ridgecrest. I won't repeat the same points made by Thank you. I won't repeat the same points made by Glendale and Watsonville, but we join in the same opposition on the same grounds. And we oppose the budget trailer bill. Ridgecrest is in a state of declared fiscal crisis. They've responded to that crisis with employee furloughs, project cancellations, departmental budget restrictions. In 2010, prior to redevelopment dissolution, the city loaned the RDA more than $3.5 million for the development of a solar energy field. The project was built. The developer of the project has been paid. A portion of the loan has already been paid off. It was memorialized in a joint resolution of the RDA and the city containing all of the essential elements of a loan. We have a concern that the budget trailer bill redefines loan from the ordinary plain meaning under California law. And under California law, the definition of a loan is established. And if a document contains certain terms, it's a loan. We have concerns that DOF is attempting to basically overturn the decision in Watsonville and other decisions on this issue, and we oppose on that basis. We also have concerns about the DOF attempting to exempt itself from the Administrative Procedures Act because we too have received inconsistent decisions from the DOF. And we're currently involved in 2 cases. The provisions on litigations costs concern us because as a city in fiscal crisis, a provision stating that the city can loan money to the RDA for litigation costs and then be repaid if they win is not much help when the city itself is in a declared state of fiscal crisis. So we have concerns about due process, the Administrative Procedures Act, and an attempt to define a loan differently than it is defined under California law.
Thank you.
So we oppose the budget trailer bill.
Mr. Chairman, members of the committee, my name is Philip Lanzafame with the City of Glendale in opposition. You've heard a lot of legal argument, a lot of expertise about this, so I'd like to approach this from fairness. The City of Glendale has done everything asked of them. We dissolved our redevelopment agency. With 1484, we thought we would have our loans repaid. In fact, the Department of Finance approved those loans for repayment, not once but twice. Then we found that there was a disagreement on interest. So we're forced to litigate that and found that, again, we were correct. Now with the new proposal, changing the game altogether by redefining what a loan is. The City of Glendale, in good faith, has done everything we were asked to do to unwind our redevelopment agency. I urge you to live up to the promises of 1484 and oppose this bill. Thank you.
Thank you.
Thank you, Mr. Chair and members. Christopher Castrillo on behalf of the City of Santa Monica. We have a number of concerns with the bill. In the interest of time, just want to stick to our main issue. That's the issue of loans, the loan agreement definition in particular. If adopted, this section would preclude a city's ability to get a loan repayment on most, if not all, of its loans. because most loans are made upon the basis of real transfer of property or capital assets to the RDA for redevelopment purposes. It was more efficient to transfer these assets to the RDA in lieu of transfers of general fund cash. So former community redevelopment law authorized RDA's payments for publicly owned land and capital facilities. Consequently, most loans were base transfers of non-cash asset transfers. Unfortunately, DOF's current interpretation of loan agreement would literally require a cash transfer of general funds between the city and the RDA, which would exclude almost all loans as understood by cities in their legislature when they adopted the carrots in the aforementioned AB 1484. We have some proposed revisions which we've circulated to the committee or counterparts in the Senate, and thank you for your time.
Thank you.
Mr. Chair, members, Anya Lawler on behalf of Western Center on Law and Poverty. While we certainly appreciate the work that's gone into the bill this far, we still have significant concerns about the negative impact on affordable housing, and we will get you detailed comments on that shortly. Thank you.
Thank you.
Good afternoon. Thank you for this time. I'm Jerry Craig. I'm with the City of Tustin, home to the former Marine Corps Air Station, and we join with the League and the other cities in opposing this bill language. The City of Tustin paid off our unobligated funds, and we requested a finding of completion. The Department of Finance denied that finding of completion. We had to go to court, which we won, and the court ordered the finance to issue that finding. At that time, we then submitted requests to be reimbursed for $42 million in loans or reimbursement agreements as they were written, but they are loans. DOF has denied that and forcing the city to file a second lawsuit. DOF knows it's on shaky legal ground and now is asking the legislature to change the rules in the middle of the process. The legislature should not assist DOF in the efforts to shirk its responsibilities and follow the law. You know, I'm a 26-year resident of Corona. I spent 12 years of my career working for Riverside County. I'm very well aware of the plight of the four incorporated cities that lost over $20 million and appreciate the efforts for this bill to bring that money in to assist those cities. I bleed the Inland Empire. It gets my friends in Orange County who I work with upset. But as much as I want to see those cities receive money, I do not think it should be at the expense of the City of Tustin and the $42 million that are owed to us through 2 reimbursement agreements. So I'd ask that you would oppose this. I would also, in terms of the LAIF rates, we support what the League is saying, but for us, the LAIF rate has no benefit if we do not get these loans reinstated. And finally, I sit in many meetings with our attorney, our special counsel, citing code, going through various legal arguments, talking about what a loan is, what isn't a loan. It seems like it comes down to a basic issue of fairness, and that is to do unto others as you would have them do unto you. There's no one in this room who would lend somebody money to either repair their car or to pay for the repair of the car, reimbursement agreement or loan, who would not expect to be paid back unless it was so stated. The city entered into an agreement expecting the redevelopment agency to pay them back. Just like if the legislature entered into agreement, you would expect to be paid back. We're asking you to do to the cities as you would want done to them. So the city of Tustin opposes this. Thank you.
Thank you.
Good afternoon, Marlene Murphy, City of Fresno. We continue to oppose the trailer bill. We're primarily concerned with 3 major issues that reverse 1484. First, it narrows the definition of loans, which would have a significant adverse impact on Fresno and other cities. We had, for example, Fresno, that is, repayment agreements documented by promissory notes with conventional terms, but because in some cases the accounting records from 20 years ago were, as permitted by law, not retained, we can't show that the cash actually passed from the city to the redevelopment agency, so those are denied. In other instances, the city, in some cases, paid obligations directly to the third party on our behalf, and those are denied. The loans were determined to be a redevelopment purpose by the Oversight Board, and they have been consistently reported as loans to the state over the last 20, 25 years in terms of our statement of indebtedness, and always accepted. But no longer with the current interpretation of the loans by DOF. Just because cash didn't pass to us doesn't mean it's not a loan. And I've used this example. When I buy a house, the lender doesn't give me the cash. The lender doesn't give me the cash. It gives the seller the cash. But this still means that I owe the money. I still have a loan. That's the same concept that's being upended here. Secondly, it undoes the court's ruling on the LAIF rate and will reduce repayment of Fresno's loans by about $41 million, which means a loss of $8 million for affordable housing, and also cutting into core services. And lastly, the bill undoes due process, as has been explained by other speakers here today. We've submitted our comments in writing, and I thank you for the opportunity to speak before you today.
Thank you.
Matt Ballantyne with the City of Chino. We have the same concerns with the bill as the City of Glendale and many of our other colleagues here. We stand to lose roughly $15.4 million for improvements that we made in the RDA or in the project area. And then as far as interest, we stand to lose about $3 million. So, thank you.
Thank you.
Good afternoon, Mr. Chair and members. My name is Martin Scheel. I'm the mayor of the City of Lakeport, and the City of Lakeport is here in support of our fellow opposing cities to the current trailer bill. And in the essence of time, we would just like to echo the concerns, comments, and recommendations provided by our fellow opposing cities and the California League of Cities. And with that, the City of Lakeport would respectfully recommend that you not support the current trailer bill in its current form. Thank you.
Thank you.
Good afternoon, Anthony Newman on behalf of the County of San Bernardino. The county actually is opposed to a different provision than most. Our problem is we have a issue with the provision that the county the auditor, the controller's roles and responsibilities will be they will have increased responsibilities under this. Currently, the auditor controller in the County of San Bernardino serves as a third-party neutral party. With the provision in the new trailer bill, the controller and auditor will sit on the oversight board, and they will have opened the county up for additional liability, which could result in litigation. Thank you.
Thank you. That's it? Quite different than the first time around in February. At this point, Mr. Hill, if you want to have an opportunity to respond to some of the questions and
Thank you, Mr.
comments.
Chairman. Taking the last one first, the bill now says that the county auditor controller, when we move to the countywide oversight board, the bill says the county auditor controller or another county entity can serve as the staff for the countywide oversight board. And if the county doesn't want to do that, the county can consult with finance and select a city to perform that role. So the county as auditor controller is not required under our bill to staff the countywide oversight board. One of the big issues regarded the LAIF rate. And we have to understand that when AB X126 was passed, it invalidated, it just cleared the decks and got rid of all city loans and loan agreements with the former RDA, unless it was a loan made within the first 2 years of the RDA's existence. AB 1484 then came along and restored those and said those can be enforceable obligations to repay those if you have a finding of completion. Now, I think it's important to note that the definition of enforceable obligation, as it speaks to loans for the city, says loans of money. Now, the finding of completion provisions in 34191.4 do say that, notwithstanding Health and Safety Code Section 34171, these loan agreements shall qualify for repayment to the city. And what I think that's saying is that any loan agreement made after the first 2 years shall qualify for repayment if you get a finding of completion. But we still have to go back to the fundamental fact that loan agreements for purposes of enforceable obligations are defined as loans of money. And so we're just following the law when we interpret that a loan of money qualifies for repayment, but reimbursement agreements do not, because those are not loans of money. Regarding the LAIF rate issue, we are proposing in our as we interpret current statute says that that loan that is now qualified for repayment when you get a finding of completion will be repaid at the LAIF rate that was operative when the Oversight Board approved repayment of that loan. And what we're saying in our trailer bills, we're increasing that to either 1% instead of the LAIF rate on the annual ROPS, or 2% in lieu of the LAIF rate if you go to the last and final ROPS. But we believe statute is very clear that it is the LAIF rate that was in place when the Oversight Board approved that loan to be repaid, because these loans were, again, they were abolished by AB X 126. They were cleaned off the books. And so the legislature said, okay, we're going to go ahead in AB 1484 and restore these as sort of a carrot, if, as other people were saying, if you get your finding of completion. But we weren't reinstating all those terms. We were saying it's going to be paid at the LAIF rate that was operative when that loan was approved by the Oversight Board for placement on the recognized obligation payment schedule. And finally, there was a discussion of maintenance costs as enforceable obligations. If right now you can claim an enforceable obligation to maintain property of the former RDA prior to dissolution, and what we were doing in our trailer bill is making clear that the maintenance does not include things such as demolishing the property. There's apparently there are some successor agencies that want to demolish property and say that's maintaining the former RDA's property prior to dissolution, and we respectfully disagree that that is in fact falls under the rubric of maintenance. But you can create enforceable obligations to maintain former RDA property prior to dissolution. And then again, there was discussion of the litigation issue and the litigation funding, and I've mentioned that before. I respectfully disagree with what the city representatives were saying. We think the fair middle ground is that instead of forcing the affected taxing entities to pay if the successor agency wants to sue the state on dissolution-related issues, we think it's more fair for the city to loan money to the successor agency for that purpose, and then if they succeed in their litigation, they get a final judgment in their favor, they can go ahead and they can claim an enforceable obligation to have that money repaid to them. But as things currently stand, it is the schools and the county and the special districts that are paying for these entities to litigate against the state. And in the vast majority of cases, sure, they have had several rulings in their favor, but in the dozens of rulings that have been issued so far, almost every one has been in the state's favor. I think those are the main issues that were mentioned by the speakers, and I'd be happy to answer any questions that members may have.
Thank you, Mr. Chair, for the opportunity. I'm still digesting all of the details here, but wanted to make some comments today. I believe this item may be coming back to us tomorrow, but I've got legislative business in my district tomorrow and won't be present. So I wanted to make some comments today. First of all, I want to thank DOF for the presentation and for the impressive mastery of detail on all of these issues. I think we are moving collectively in the right direction on a number of fronts on this. I want to thank DOF for working with local governments. I'm hoping to see a reasonable compromise on this LAIF rate issue. Of particular interest to me, I carried legislation on LAIF rate, which I was told was something of a non-starter right out of the gate. But in retrospect, I think I might have actually resolved the issue more favorably than has been seen in the recent court case. But just a particular interest in that. As somebody who hails from the San Francisco Bay Area and who can't go a day without hearing about the affordable housing issue, that gives me some concern on what impacts this whole conversation has on affordable housing. And I do have some concern, again, about retroactivity with regard to court decisions. That being said, I am hopeful that this issue, the LAIF rate issue in particular, can be worked through. My preference would be an examination of the historical interest rate calculation to come up with some reasonable approach. But just, I guess, a general word of interest that DOF continues to work with the localities, many of whom came out today, and who are on the ground in their communities. As a former council member and mayor who was presiding as redevelopment was undone in my community, this issue is personal to me. So, but I am seeing some positive movements on DOF's part. I want to thank you for that. But please take some of these comments to heart from our localities and see if we can't move in their direction and see if we can't find some compromise. And with that, I'll turn it back to the chair.
Thank you. And my comments were going to be very similar, even though I humored all of you a moment ago by asking if that was the end of the opposition, because the first time around when we had the hearing, we didn't even have a single supportive representative of any of the cities. And so I believe the Department of Finance has come a long way in trying to work out certain details. And while there are some individuals still, some of the cities still that are affected and still are looking for some form of resolution, this by no means is the final step. This week is just the conclusion of the subcommittees, and what moves forward after that is a framework that is going to continue on into conference. So first and foremost, I'm very pleased that there's been at least enough work done to try to, in some step, reduce the number of opposition. That said, what I don't want to incite is many representatives flying up for tomorrow's hearing at this point. But I do think that Department of Finance, even in the areas that there are still disagreements, have made it abundantly clear that they want to find an opportunity to work with the affected cities. So, and if I'm misunderstanding that, Mr. Hill, please correct me. But from every indication, thank you. From every indication I've gotten, there's an opportunity to still work on this. So, with that said, please.
One more quick one, Mr. Chair. I'd be remiss if I didn't acknowledge DOF and their acknowledgement of the insufficient ERAF issue and its impact on my home community of San Mateo County. DOF has listened to us on this issue, and I wanted to at least note that for the record. Thank you.
So with that, if there are any other final comments that you'd like to make?
Just actually one point related to that insufficient ERAF issue is we did include it in the trailer bill, and so as a consequence, we prior to that, in the governor's budget, we had a budget bill item to provide that funding for the insufficient ERAF issue, but then we moved it into the trailer bill. But we subsequently learned from legislative counsel that having it in the trailer bill could pose a problem because we had two appropriations, and that could be unconstitutional. So we'd respectfully request that the subcommittee deny our finance letter to strike that funding from the budget bill. And we'd also respectfully request that you augment the budget bill item by $679,000 to ensure that Amador and San Mateo County receive full reimbursement for their insufficient ERAF costs.
Thank you, and I believe it's going to be agendized for tomorrow.
Oh, great.
Thank you. So with that, again, this item is going to be held open. Thank you for all of your comments and suggested amendments. All will be taken by staff and continue to be worked on. For now, this committee is adjourned until tomorrow. Thank you.